the law doesn't require of him essentially to even be explaining to us or giving us reasons for filing Nolle Prosequi. In the spirit of transparency, he says this is what he wants to do. Is that doing him much good or opening him up for more scrutiny? I'll start off with you because you're a lawyer on this panel. I have Lawyer Martin. People join us in a bit as well. This path that he is taking, in the interest of transparency, yes, he's ticking a number of boxes as well. But then, is that doing him any good or opening himself up for more scrutiny?
No, I think it's public accountability, and as you were said, we are witnessing a new Attorney General who is being open to the public, telling the public, these are my plans and these are the things I'm doing. There are a number of cases I inherited, and I've decided, looking into the facts and the evidence gathered so far, I feel I need to discontinue some of them. And you rightly put it, Section 54 of Act 30 gives the Attorney General the power to enter a Nolle Prosequi. And there's a string of judicial authorities or judicial cases where our courts have held that the AG need not explain the reason for filing the Nolle Prosequi or the reason for discontinuing any matter. But you see, we need to just understand something. I think Ghana is caught up in what I describe as the corruption and impunity trap. And there are two theories, Alfred. There are two theories when that some researchers use when discussing issues of corruption. And the first is the principal agent theory. And the second is the collective action theory. Now, the principal agent theory highlights the relationship between individuals in the society. And it says that the agents, in this case, public officers, are assumed to work to protect the interests of the principal, which is the state or the public. But the reality has always been that the interest of the agent always takes precedence over that of the principal. And this creates what they call the agency problem. So to limit this problem, it has always been the policy of the principal to put in place measures, which include laws. So you can say our laws, or the laws we have, form part of the measures to control or limit the potential abuses of the powers given to the agent. Now, the second one is the collective action theory. Now, this theory goes beyond the principal agent theory, and it considers trust. So the collective action theory considers trust and the perceived behaviors of people in the society.
Right.
Now, this is what it means. People begin to rationalize their behavior based on what they perceive others to have done or would do given the same situation. Now, if as an Attorney General, you want to be entering Nolle Prosequi or be filing the Nolle Prosequi to discontinue certain cases and be entering into a contract with people, accused persons, to pay a percentage of the principal sum. What are you trying to do? You are trying to push forth the arguments or the position that it is okay to dupe the state, to pillage the state, to steal from the publicity. And when you are done, the state will offer you this opportunity. You will pay instead of the principal sum plus interest. The state will offer you. Now, Alfred, let me be clear that the Attorney General has every right. And you see, when you look at Section 35 of the Court Act 1993, Act 459, it gives opportunity to any accused person to compensate the state for any economic harm caused. So it is within the right of any accused persons to enter into such an agreement with the government. But it should always be a policy reason why you must always, instead of when you have the two options of deciding on whether to opt for the compensation or opt for punishment or sentence that will serve as a deterrent, I will always say that it must always be a public policy to punish, slap, make sure that sentence is imposed on people, accused persons, to serve as a deterrent to others. Because people are watching us. If today it is now becoming maybe the new habit, the habit of this new, because let me put on record, this Attorney General has entered into more Nolle Prosequi than within less than 6 months than any administration that I've witnessed. When they were just sworn in, within the space of few weeks, he entered into a string of Nolle Prosequi just to discontinue cases against high-profile individuals in the NDC. But you see, after what I'm saying is that this trajectory is aiming to normalize corrupt practices.
He indicated that the approach and the focus now is to ensure recovery, but not also water down deterrence as well. So if you have seen the path that this Attorney General is taking, and that's in tandem with the administration's recovery of all loot. So that recovery process is what has informed a number of these. You hear him talk about deals or some agreements that he's entered into some persons in other cases that he's investigating to, apart from reaching that deal, also serve as prosecution witnesses as well. How about that?
Alfred, you see, the thing is that, like as I intimated earlier, if you have the two options of opting for one compensation and opting for sentence, I think it must always be in the interest of the society for the government to opt for the sentence. Why? So the question is, does Ghana need money? Obviously. But Ghana also need to, nurture corruptless people. What would be the need of having money if finally it will be supervised by people who have corrupt mentality? If you have money, if you have a whole room filled with money, yet the people who are supervising the money are not men and women of integrity, what would be the use? Now, you see, when you look at Article 37(1) of the Constitution, it gives the state the opportunity to secure a good social order. A good social order in tandem with probity and accountability. Social order. So when we talk about social order, we are talking about a set of institutions that help to maintain and enforce norms and laws. And it is always you see, we have, as citizens, we have duties. When you look at Article 41F, we have a duty as citizens to protect the public, to protect public property. So when people fail to protect public property, it should always be in the interest of the government to punish them, to serve as a strong signal to others who are watching. You see, and and one of the aims of punishment is deterrence, to deter others. But often than not, the behaviors of Ghanaians today reflect on our government, past and present. So if we are not scared of corruption, it is because of the behaviors of our government. Because the government, as our government, past and present, have been lethargic towards this corruption fight. And we are witnessing one. If you have an option of, ORA says, okay, I will recover everything. But you must always know that in recovering, the sanction must be punitive. You see, I'm not against recovering any money. Alfred, here's the thing. If you want to recover the money in the case of Dufour, BOG audit says 5.7 billion. The AG says it has been revised to 3.3 billion. So if you want to recover any money, and if you want it to be punitive enough, go for the 100% plus interest.
So you see, that brings me to the next issue about the amounts that have been mentioned in this particular case. It's evolved. And if you follow this case right from May 2018 till now, you've seen the evolution of this case, and that tells a story. And I'm going to go through it very briefly, because that also is important in understanding why we are where we are at this point. Because a number of conversations that you have had on this case has been about the outcome, the decision that the Attorney General has arrived at. But it started from a point. And the 5.7 billion you mentioned, is in fact, it started from 4.8 billion, if you recall. That was in May 2018. the first figure that the administrator that was appointed to oversee the entire process when this whole banking sector cleanup started, Amano Dodu, who was with KPMG. The first figure that was mentioned sometime in May, in fact, it was on the 31st of May, that report that KPMG put out was 4.9 billion. Then in June 2018, there was a revised figure of 5.7 billion. So that's how it evolved. Then later, if you look at the KPMG report, and let's flip to the next. This same administrator, Niamano Dodu, in that KPMG audit and the report on this entire Unibank matter, there's a portion of it that is quoted and attributed to him. That, quote, we have not sought to verify information or perform procedures necessary to express an audit opinion on any financial, non-financial information contained in the said report on Unibank. Then it goes on to say that accordingly, we are unable to determine the extent to which information provided to us are complete and accurate. And the report should be read in that context. So that 5.7 billion that you reference, this particular statement brings a certain angle to it that even the KPMG itself, at that point, were unable to determine the extent to which information provided to them were complete and accurate. And that's why you saw the figures changing. And the report should be read in that context. That's instructive. Then we go to the next. It's saying something as well. These were the causes for the Unibank collapse. And we're laying the foundation so people understand, maybe for the uninitiated who have not followed this case. Liquidity and solvency gap, unmet payment obligation, misuse of liquidity support. These were the identified causes of the Unibank collapse. If you look at the proposal of the shareholders of Unibank to resolve this matter, the 5.7 billion that you mentioned, this was their proposal to the central bank at the time. One, that they will, this was offered on June 5, that they would inject 1 billion Ghana cedis by mid-July 2018, and that they would inject another 1 billion before September end 2018, and then they will provide 3.7 billion cedis in assets. And at the time, the government of Ghana was also owing Unibank. And so the fourth proposal was that Bank of Ghana and Government of Ghana settle your debts to us, and then we will be able to raise the 5.7 billion that this audit by KPMG has identified. And in fact, this story about Government of Ghana owing a number of the banks that went down is synonymous to a number of them. GN Bank, for instance,
GN Bank, yes.
It had a number of contractors who had taken money from the bank, and so they said, look, these contractors took money to execute Government of Ghana projects. So government pay us, and then we'll be able to meet it. That did not happen. But then it goes on to tell you, as of the end of December 2017, in terms of the assets of Unibank, that Government of Ghana held 3.1 billion. This was how much Government of Ghana owed Unibank. Let me break that down for you. It was the Government of Ghana guaranteed loans of 457 million, public institution loans for 46 million, export guaranteed loans 114 million, Government of Ghana mortgage loans 9.3 million, treasury bills 1.1 billion, ESLA bond 131 million, cash and short-term funds 233 million, and the unpaid guarantees that the Government of Ghana had held in Unibank at the time, 1.3 billion. All of this tells you that at that point, there had to be a decision taken. The managers of the central bank who were managing the entire process decided to go in for the other one of closing down the bank, even with this detail. But as of March 26, 2024, just last year, the receiver went to court in this same Republic versus Kwabena Dufo and 7 others. And this 5.7 billion was revised downwards to 2.8 billion. This was in court. And this is data and verifiable information with the court documents that is on this particular case. With this detail giving, the Attorney General says, looking at what is before him, if he had even pursued the case, we may end up at the point where we may get very little or nothing than what he is pursuing. With the details I have just given to you, what picture does this tell you?
Alfred, and I want to maintain. You see, with this case, there are claims of accounting malpractices, padding up numbers. I don't know if you have heard of that. There are claims like that. In
fact, we'll get into that. Because the Attorney General himself acknowledges that.
Exactly.
Some 2.1 billion.
Yeah, so padding up numbers. And this one, you don't need anybody, a soothsayer to tell you that this is a palpable offense. You are padding up numbers to deceive a public officer, to deceive Bank of Ghana. That is an offense under our laws. And in this case, you don't need to pamper the person. Is it because
prosecutor?
No, just go for the long haul. And like we always say, go for the jugular. Why must you go for the jugular? Because people are listening. You are padding up numbers. There are other banks that are still in operation, and you change figures to deceive the Bank of Ghana just to look good in the eyes of the Bank of Ghana. That is no. We must discourage this kind of offense. So in a situation like this, Alfred, it should not be in the interest of the government to recoup or recover any money or to even go for compensation. Because, this is a major issue.
You should let the money go.
No, why would there are certain offenses you must not gloss over because of what you are because of what you may be doing to present and future generation.
Yeah.
People are in their various homes. People in primary school, those in secondary school, those in the tertiary, they are listening, they are watching, they are reading the news, they know what is happening, they watch the Attorney General. Padding up numbers, this is an offense. Why should you falsify data to deceive public official and you say, I'm going for the money? I'm saying that, Prof, there are situations where you opt for compensation, but there are instances where you must be punitive, you must punish the person to send a strong signal to others who may be engaging in such practices. I mean, mind you, or we may not even know that maybe behind us, there are other banks that are doing similar things. So when you send a strong signal, it will jot them out of their midnight sleep. And this will help us to, nurture a society of conscience. That is what we want. I'm not against recovery, but I'm saying that padding up numbers and other things, sometimes you have to weigh the offense and the nature of the offense and say that in this case, we don't need a compensation. Let's go for the jugular. Let's punish the person. Send a strong signal to others, just to reset the society. But Alfred, with the part that this AG is taking, I shall have to say that he is resetting his office to promote corruption.
And why is that? Because
you are normalizing corrupt practices, encouraging compensation when at a point you need, because that's what I'm saying, that as a government is like a parent with the responsibility of modeling the behaviors of the children, in this case the citizen. So if you have two options, one to opt for compensation and another to punish, sometimes you must also always think about the future of your children and say that instead of going for compensation in this instance, let me go for the punishment, just to model the behaviors of my people for future.
Okay, now Jackson.